Kanun is up next on our broadcast agenda. Host the famous and popular himself, Attorney Raja Bhandari from the law offices of Raja Bhandari and Sex and Settlements. On this good Sunday afternoon, Attorney Bhandari is going to point out to us what is a trust. Let's find out.
Good afternoon, this is Raja Bhandari from Sex and Settlements and Raja Bhandari Law Offices of Annandale, Virginia. Welcome back to Kanun. Friends, thank you so much again for your support for Kanun. This is your program. Of course, your answers we are trying to accommodate as many as possible. We will be talking about on will and trust. Now, the question is estate planning. What is estate planning is that, of course, it's not going to be in one segment. I will be doing in a very long way, in lengthy way that I can explain everything, what is exactly it is. Now, estate planning is that we, it is a compiled of several documents. We have a trust agreement, it can be living trust, revocable trust, irrevocable trust, and then it can be basically your medical power of attorney, living will, pour over will, and then general power of attorney, durable power of attorney, and then of course assignment from one spouse to the other. So there are several documents in the estate planning which we discussed mostly one by one before. However, the main major component of the estate planning is the trust agreement. Now, trust agreement is like law treat trust as a separate person. Of course, it depends how you create it. If it is irrevocable, then it is obviously related to your taxes, and then you have to file taxes according to that trust. If it is a revocable trust and between husband and wife, obviously then it is nothing to do with your taxes. Of course, you can talk to your tax person regarding this. Now, the trust is a separate person as far as law is concerned. Obviously, when you prepare a trust, it is a let's talk about revocable trust. Now, the revocable trust you have, as its name suggests, you have right to revoke, you have right to amend, rescind any way you want during your lifetime. Well, usually most of the time it can be a family trust or it can be a passover trust between the spouses. That's what we recommend for the tax purposes. So let's say that when we prepare now another questions popped up in my mind is that, is it trust is new? No, it is not. Over last 400 years, it has been used a very successful tool to save a lot of hassle, a lot of money when it comes to taxes, and a lot of time, and then it goes very smooth transaction if it is properly written, properly executed, and properly funded. Now, revocable trust, that's how we prepare. And how does it work? It's a trust is an agreement between you and a trustee and the spouses. That's how it is happened. You can be your own trustee during your lifetime, or you can appoint a third party trustee for you, and or you can be a settler of your own trust. Again, most of the time this is how we do. When we prepare a revocable trust, what we do is that we prepare two trusts, one for one husband and wife, and then it pass over later on when if one person dies. Now, how does it help you when you are alive and when you are gone from this world? While you are alive, you can manage your own assets in the trust. Of course, you can buy any property when you have a trust, or you can dispose of any property during the lifetime of yours. So, you have the complete power to do anything you want because you are your own trustee and beneficiary as well during your lifetime. So, for example, let's hypothetically speaking that there is a husband and wife, and we created two trusts, revocable trust, one for husband and one for wife. And in that particular trust, we gave powers to husband in case he dies, everything goes to wife, and it's vice versa. So, then we also prepare a document which we call assignment of trust, that will be for personal property as well other properties, that when husband dies, he or he assign all the properties owned by him as a person rather, or in the trust assigned to the wife. So, same thing wife does. So, and at the same time, let's say that both husband and wife has two kids, and both are over 21 years. So then when we make them a successor trustee in the trust, if you die, everything goes to your wife, and if wife dies, everything goes to you. If both of you die, then you appoint both of your son as a successor trustee as well as beneficiary. So they have the same right as you have during your lifetime. They can dispose of the property and distribute among themselves the way you directed, and they do not have to go to probate. That is the key question, that how you can save the probate road. And when you are saving that probate, means you are not going to court, you are saving lots of money and taxes and hassles. I will be discussing next time how the procedure works, that how you can avoid altogether the probate section of the code, and then you don't have to go through that particular area. So next time I will be discussing how to avoid the probate in the trust. So friends, if you have any questions regarding trust, regarding will, regarding medical power of attorney or power of attorney, or for any related issue in this particular area, please send us your email or phone, so then we can call you back or we can entertain your questions. Time is up for today. Remember, if you don't have a will, fate of your children is in the hands of state. So long.